Hello students, KTHM College, Department of Political Science. Myself Chandanshive Vasudha welcome you all again for the subject Introduction to Constitution. In previous lecture, we have learned the fundamental right. In that, right to equality we have learned. Now in this lecture, we are going to learn right to freedom. So we will start with our lecture. We have already seen the unit and its subtopic: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, right to property. After that, right to constitutional remedies. Next fundamental right, that is right to freedom, which is from 19 article to 22. So the first one is protection of six rights regarding freedom, which is in article 19. So there are six rights in article 19, that are speech and expression, right to freedom of speech and expression, right to freedom of assembly, associations, movement, residence, and professions. So the first one is freedom of speech and expressions. So uh, the Supreme Court held that the freedom of speech and expressions includes some dimensions in that. So we will see them. The first one is right to propagate one's view as well as view of others, freedom of the press, freedom of commercial advertisements, right against tapping of telephonic conversation, right to telecast, that is government has no monopoly on electrical media, right against wound called by the political parties or organization, right to know about government activities, freedom of silence, right against imposition of pre-concerned consorship or on a newspaper, right to demonstrate or picking but not right to strike. The state can impose reasonable restrictions on the exercise of freedom of speech and expression on the grounds of sovereignty and integrity of India, security of states, friend relations with foreign states, public orders, defenses or morality, and uh, insamentum to an offense. So this is in speech and expression, right to freedom of speech and expression. After that, freedom of assembly. Every citizen has the right to assemble peacefully and without arms. It includes the right to hold public meetings, demonstration, and take out processions. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies or on that causes breach of public peace or one that violates arms. This right does not include the right to strike. So this is the second one. After that, movement. Freedom to movement. This freedom entitles every citizen to move freely throughout the territory of country. He or she can move freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling and not parochialism. After that, the fifth one is residence. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of a country. This right has two parts. The first one is the right to reside in any part of the country, which means to stay at any place temporarily, and the right to settle in any part of country, which means to set up a home or domicile at any place permanently, including Jammu and Kashmir now as well. After that, the sixth one is freedom of professions and etc. All citizens are given the right to practice and professions or to carry on any occupation, trade or business. This right is very wide as it covers all the means of earning one's livelihood. So this is the first article of right to freedom, that is Article 19. Article 20. So it is protection in respect of convictions for offences. So Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner, or legal person like a company or a corporation. So it contains some provisions. So Article 20 has some provisions. So the first is no ex post facto law. So in that, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act. And the second one is no person shall be subjected to a penalty greater than the prescribed by the law in force at the time of the commission of the act. This is the first provision. The second one is no double jeopardy. That means in that no person shall be prosecuted and punished for the same offense more than once. And the third and last one is no self incrimination. No, in that no person accused of any offense shall be compelled to be a witness against himself. So this is Article 20. After that, we will see Article 21, which is protection of life and personal liberty. So Article 21 declares that person shall be deprived of his life or personal liberty except uh, except according to procedure established by law. This article this article or right is available to both citizen or non-citizen. So this article is cornerstone amongst all the fundamental rights. This article not only exists protection from the unauthorized legal acts of the state, but at the same time extend to cover a wide variation of rights that are necessary for the natural person to lead a life with minimum amount of decency. And this article guarantees a natural person a number of rights that are guaranteed under the various provisions of fundamental rights and directive principles of the fundamental rights. Directive principle which need to be honored and respected by the citizen in order to ensure to lead a life with dignity. So there are some there are some rights in Article 21. So there are 26 rights. So we will go through it once. So there, the first one is right to live with human dignity. After that, right to decent environment, including pollution free water and air, and protection against hazardous industries. After that, right to livelihood, right to privacy, right to shelter, right to health, right to free education up to 14 years of age, right to free legal aid, right against solitary confinement, right to speedy trial, right against handcuffing, right against inhuman treatment, right against delayed executions, right to travel abroad, right against bonded labor, right against custodial harassment, right to emergency medical aid, right to timely medical treatment in government hospital, right not to be driven out of the state, right to fair trial, right to prisoner to have necessity of life, right of women to be treated with decent and dignity, right against public hanging, right to hearing, right to information, right to reputation. So there are 26 right given in the article 21. So this is article 21. In that article, sub article of article 21 is 21A, which is right to elementary education. So article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only elementary education a fundamental right and not higher or professional educations. So, this provision was added by 86 Constitutional Amendment Acts of 2002. This amendment is a major milestone in the country's aim to achieve education for all. The country described this step as the dawn of the second revolution in chapter of citizen. So, citizens' right. Even before this amendment, the Constitution contained a provision for free and compulsory education for children. So, however, being a directive principle, it was not enforceable by the courts. Now, there is a scope for judicial intervention in this regard. So, this directive principle made the fundamental rights. This amendment changed the subject matter of Article 45 in directive principle. It now reads the state shall endeavor to provide early childhood care and education for the children until they complete the age of 6 years. So, this is right to education. After that, the Article 22, the last article of right to freedom, is protection against arrest and detention in certain cases. So, Article 22 grants protection to persons who are arrested or detained. So, detention is of two types, namely punitive and preventive. So, punitive detention is to punish a person for an offense committed by him after trial and conviction in a court, and preventing detention is on the other hand means detention of person without trial and conviction by the courts. Its purpose is not to punish a person for a past offense, but to prevent him from committing an offense in the near future. Thus, prevention detention is only to prosecute prosecutionary measure and based on suspicious. So, there are some preventing cases have been done and the provisions are made. So, the first part of Article 22 confers the some rights that is the right to be informed on the grounds of arrest, right to consult and be defended by a legal partitioner. After that, right to be produced before a magistrate within 24 hours excluding the journey time. After that, right to be released after 24 hours unless a magistrate authorized further detentions. This is article A. After that, the second article is the detention of person cannot exceed 3 months until an advisory board reports sufficient cause for extended detention. This board is to consist of judges of high courts. After that, the grounds of detention should be communicated to be detained. However, the facts considered to be against the public interest need not to be disclosed. The detainee should be afforded an opportunity to make the representation against the detention. So these are the some circumstances and some rights under the Article 22. So this is this is right to freedom. We have seen article from Article 19 to 22. So thank you all of you.